dangerous drugs, car crash cases, injuries, and abuse. Across the state of Alabama, the attorneys of Hollis, Wright & Couch are here to serve you. With civil trial lawyer Josh Wright from the firm of Hollis, Wright & Couch and Alabama's 13 host David Lamb, the attorneys answer your tough legal questions straight ahead.
Hello and welcome into the attorneys. Thanks so much for joining us tonight. This is where your tough legal questions get answered by our panel of experts. And for the next half hour, we want to welcome you to get in touch with us and correspond with us. You can call, text, or email your legal questions to us 24/7. Our goal tonight is to provide answers and legal counsel whenever you need it most. And we are joined once again by Josh Wright of the firm Hollis, Wright & Couch. Good to see you, sir.
Good to see you, too. This is a great topic this week because it is really an education of the public of questions they probably have when they sit in our jury system as to why wasn't I able to hear about that information?
Right.
Why didn't that evidence come in? And it's just a good education of some of the things that aren't able to come in. We've brought on with us Courtney French from Fuston, Petway French. Courtney's a partner at his firm, does a lot of civil litigation, excellent lawyer, in fact, a former Alabama Association for Justice president. We're just excited to have you on and talk about these topics and help educate some of the public.
Well, thank you for having me on the show. You're right. This is a topic, I think, that when you think about things when people are on the juries and they have questions of the lawyers during the course of the trial, why don't we know about this? And they send questions out to the lawyers and to the judge. And so hopefully during this show we can talk about some of those issues and answer some of those questions.
And I think one of the misnomers is that information is being withheld by choice, it appears. What are the motivations for the withholding of information that maybe someone thinks they should know or should get to know? Yeah.
Well, as lawyers, we're bound by the rules of law, and some of the things we're going to talk about today, it's just a law that's been passed by the Alabama legislature. For example, during the course of a trial, if you take a typical car wreck case where someone's been injured and badly injured, the one thing that you do not hear during the course of the trial is the fact that the defendant who's being sued for causing the collision has liability insurance that's actually paying for the plaintiff's damages. That never comes up, and you can't even talk about that during the course of the trial. In fact, it's the insurance company that's also paying for the lawyers for the defendant. Right. And so those are the rules that we have to play by, but that's a question that's always in the back of the mind of the jurors, and sometimes we're asked during trial, well, who's having to pay for this? Yeah. And so you may have like we've recently tried a case where significant damages, and you take a person that's an average job, in the juror's mind, they're thinking, well, how are they going to be able to pay for this? Right. And oftentimes there's sufficient and substantial insurance coverage that's actually paying for the damage, but that's one thing that by law that's been passed by the Alabama legislature that we're unable to tell the juries during the course of the trial.
Yeah, that's exactly right. Let me raise a couple other issues too. There is, as Courtney indicated, we are really bound by the rule of law. The rule of law has also helped establish certain rules that apply to lawyers during trial that we follow, called the rules of evidence. The rules of evidence are hundreds of years worth of wisdom as to what evidence is appropriate, what evidence is accurate, and what evidence can be considered credible in front of a jury. And so, for example, we have rules of hearsay, and oftentimes you'll hear people in layman terms talk about hearsay, that I know something through hearsay. Well, there's a reason why only certain hearsay evidence gets in front of the jury. And the rule of law has established that over a very long period of time. And so Courtney's exactly right. The Alabama legislature, in many circumstances, has outlined certain rules and regulations that we've got to follow. But the rule of law and the rules of evidence also outline certain other things. Courtney's touched on one of many things we get to talk about today, and we made the show about 10 things, but the reality is there are a lot more. And, the typical juror, I think, David, recognizes that under Alabama law, every person that operates a motor vehicle in our state has to have insurance. So I think the typical juror is smart enough and wise enough to recognize that the insurance company that is representing the defendant in an accident case is there to pay the judgment, whatever that judgment may be, for that individual. But It's just not something we can talk about. Right. And I often close cases, I know Courtney probably does too, saying to the jury, I wish that I knew what your questions were right now so I could answer them all, but unfortunately I can't, because I can't ask the jury a question. And this is just one of those examples of, gosh, I wish I could tell the jury there is liability insurance. We're not trying to punish this individual who is a hard-working person that had an accident that caused this accident, maybe was texting while driving, and unfortunately that's just one of those things we can't talk about.
And of the 10, the first 3 seem to really have to do with insurance in some form.
Well, in most cases, insurance is always a big issue. One, liability insurance. Who's having to pay for the compensation that you're asking for the damages the plaintiff is claiming? Well, in cases, the judge oftentimes will give an instruction that says you can't be sympathetic towards either party. And a part of that that we have to deal with on our end is when you ask a jury to render a substantial verdict, sometimes hundreds of thousands of dollars in damages that a plaintiff has suffered, or maybe millions. The jury shouldn't worry about, well, is this person going to actually have to pay for that, or how can they pay for that on what they make. However, as Josh said, it's the law in Alabama. It's mandated. Everyone has to carry liability insurance coverage if you're dealing with an accident. When there's a business, oftentimes people just sort of assume that insurance is there. But in most of the cases, they're third-party liability cases where you're suing an individual. If you have a claim against your own insurance company, it's what we call a first-party claim, where they're actually named as a party, then obviously they know that the insurance is available for that.
There are some pretty limited exceptions to what I'm about to state, but the reality is most lawyers are not going to take a case all the way to trial unless there's some form of liability coverage, for obvious reasons, because to do so, simply to make a statement, doesn't really make a whole lot of sense if you're not able to compensate your client. You want to make sure you're compensating your client. So there, with some limited circumstances and exceptions, there's going to be some form of insurance if a case goes all the way to trial. I mean, that's the general rule. If we're talking about 10 things that people don't know to educate the public, that's one of those rules.
A hypothetical here. Say someone serves on a jury in an automobile crash case. The attorneys had a long fight about a police officer testifying about the accident. The question that it raises, why can't a police officer tell us who he thought was at fault?
That's correct.
Well, again, that's one of the other prohibitions as it relates to the rules of evidence and the rules of law. Police officers are trained to investigate accidents. I mean, they go through a significant amount of time through the academy and learning how to take statements from witnesses, look at the accident scenes. There are some who are actually certified as accident reconstructionists, and the law really allows for those who have that type of training and background to come in and talk about who's actually at fault. But when you receive the accident report, there's a box on the report that says, this person, whether unit 1 or 2, this is the prime contributing unit number. That's the officer's opinion about who's at fault for causing the collision. But again, it's one of the prohibitions when you have a police officer that comes to trial. A question that the jury wants to hear is, Mr. Officer, tell me who's at fault for causing this collision. Well, by law, the way that rules of evidence work, that's the ultimate question that the jury has to determine.
Right.
And so because of that since the jury is sitting there making that determination, the officer can.
Okay. All right. On that note, we're going to head to our first break. But don't forget, you can call, text, or email us. We would love to hear from you. Get your legal questions right to our panel of experts here to answer you and help you with your legal battles. Contact them all throughout the show. You can also find them on Facebook. Just search Hollis, Wright, and Couch. Follow them on Twitter at Hollis_Wright. Much more on this topic right after the break. The attorneys are coming right back.
I'm Josh Wright with the law firm of Hollis, Wright, and Couch, and thanks for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, Call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the attorneys link. We know your time is valuable, so thank you for spending it with us and for watching The Attorneys right here on Alabama's 13.
That one is fascinating. More on that coming up. Just a reminder, all throughout the show, we would love to hear from you throughout this program. And until we are on tonight, you'll see ways that you can get in touch with us by text, call, or email. Please do that. We would love to hear from you. And Josh, as we went to break, we were dealing with this about maybe why a police officer withholding some information or not giving opinions. Looked like you had something you wanted to add?
Yeah, I think, just to add a little additional information to what Courtney was mentioning, generally I think what you will find is officers, if they don't actually witness an accident, so they're not present, they don't see it, and that's 99% of the time, right? They do not have the ability to cite an individual with a traffic violation unless it is DUI, through a DUI,
okay,
or through failure to carry insurance. There are some exceptions to that, but for the most part, those are the only ways that an officer can cite somebody with a traffic violation. So oftentimes in cases that Courtney and I have, whether it's tractor-trailer accidents or a typical car accident case, I know the jury is asking themselves the question, because we talk with juries after cases to figure out how we can improve our craft and get better. They're asking questions sometimes, well, why didn't the officer cite that person with a violation? And the reality is, it's not something we can generally talk about in front of the jury, but the rule generally is that it's hearsay for the officer to be able to testify as to who was at fault, how the accident was caused, unless he's a certified accident reconstructionist. And so, that's just one of those other things that, unfortunately, the jury's probably never going to hear. But in educating the public about these issues, they need to know why. And that's one of the reasons why.
And one final thing, too, about the officer's testimony, in addition to their making a call who's at fault, the accident report is also hearsay. Oftentimes jurors will say, well, why didn't you admit the accident report into evidence for us to just look at the report for ourselves? Right. We're also prohibited from introducing that as evidence in the case, in most cases.
When we were coming back from break, I don't know if you all caught the graphic there about medical malpractice. Let's talk a little about that, because honestly that is surprising to me. And just to help the folks, it is that if past instances of medical malpractice is not admissible?
Yeah, Courtney just raised a great point that segues really into this new topic of medical malpractice. His point was that accident reports are not admissible. That's by statute. Courtney started at the top of the show talking about the fact that the Alabama legislature implements certain rules and certain laws that apply. The same thing is true with medical malpractice as it is with the incident report. In medical malpractice cases, the Alabama legislature has adopted the Medical Liability Act. And in the Medical Liability Act, there are certain very strict rules that are totally different, totally separate than the regular public walking around, the rules that apply to us. They apply different to doctors. One of those is other similar incidences, so other acts of malpractice where a physician has committed malpractice, even in our own community, are not admissible at any point in any time throughout the course of the litigation. So this is even before you get to the jury, and when you get to the jury. So the jury never hears about other acts of malpractice, and that's something that oftentimes from a lawyer's perspective, when you have knowledge of things that have happened in the past, it's extremely frustrating.
And I think also it's really bad public policy. If you have a doctor who's committed many acts of negligence and malpractice, you would want people to know about that. But the way that the law works under the Medical Liability Act, oftentimes we don't know that information. And the reason why is there's a very strong lobby that the doctors have in Montgomery, where the laws are passed who represents their interest. So when these laws are proposed and they go to our legislators, doctors are really the only group that have that type of protection. If you had a driver who was a drunk driver who had caused a collision, and you had a case where that driver had been drunk before and caused 5 other collisions while drunk, that comes into evidence. And in most other instances, you can talk about that because it shows a habit, it shows a pattern and a practice, and it's certainly relevant. But for doctors under the Alabama Medical Liability Act, OSIs, as we call them, for similar incidences, they never come in. And by law, we are precluded from even mentioning the fact that this doctor could have committed that same act of negligence the week before that.
And let me add a couple quick points to that because I think it's important. One, of course, we're not indicting an industry, the medical liability industry or the medical physicians and the care they provide. And here's why. Oftentimes when I talk with doctors that are friends of mine, they don't recognize what some of these laws are and how they apply. I've had physicians tell me specifically, are you kidding me? I want people to know if I'm ever sued that I have not been sued previously or that I have not committed malpractice previously because it makes me look like I know what I'm doing. And so it is a bad public policy. It hurts patients, and it also in some respects hurts physicians who do it the right way and are doing it the right way on a daily basis. And so it's just another shining example of those things where a juror may get in that jury box and say, gosh, why didn't they talk about that? And unfortunately, the rules are what they are, and we're bound to follow those. And it's one of those things that you can't talk about. Another example in the medical context is quality assurance evaluations. Hospitals routinely do quality assurance evaluations where they will come in and evaluate the conduct of a physician. Oftentimes, in evaluating the conduct of a physician, they find the physician's doing it absolutely the right way. Sometimes they find in their quality assurance evaluations the physician is not doing it the right way, yet they continue to maintain them on staff and allow them to continue to act in a manner that could be argued inappropriate with other patients on a moving forward basis because they recognize and have knowledge that a jury will never hear those things.
While we're on the subject of medical, kind of the medical field, HIPAA. I wonder how HIPAA has affected, because it certainly has affected so many in the coverage of news stories. Oftentimes reporters will complain a hospital can't release that information. How does it affect, and does it often, I see that it made your list here. Why? How so?
Well, HIPAA, it really governs medical information. It stands for the Health and Portability Accountability Act. And what HIPAA does, if you go into a hospital and you want a release of information, you have to sign a HIPAA release. It's federal law. Which governs what information is disclosed regarding medical treatment from medical providers. Oftentimes, during the course of litigation, if you sign a HIPAA release and you allow the other side to get information about your injuries, really it opens up the floodgates where they can actually go into your entire medical background, and oftentimes they do, not just to look at what's related to this collision and the injuries that you're claiming, but any injuries that you've ever complained of, and we see that oftentimes in cases where you sign a HIPAA form and it allows other lawyers to call your doctors and to get all of your information.
So be careful what you turn over. Be careful what you sign off on. When you're signing those HIPAA forms, know what you're signing, because you may very well be signing in a circumstance where you've been injured at somebody else's fault. You may be signing away your right to allow a third party like a lawyer or insurance company for the defendant who caused your injury to go talk with your physician. So be very careful about it.
And I hear that piece of advice quite a bit. Know what you are signing. We're wrapping up our headed to our second break. One final segment with the attorneys. As we head to break, a reminder, we would love to hear from you. There's the information on how you can get in touch with us. Also, you can find the firm of Hollis, Wright & Couch on Facebook. Just search Hollis, Wright & Couch. And on Twitter as well, Hollis_Wright. Stay tuned. Our final segment is coming right up with the attorney.
From all of us at the law firm of Hollis, Wright & Couch, we're glad to have you here with us every Sunday night on Alabama's 13th. This week, we're discussing some of the things that lawyers are not allowed to talk about or introduce as evidence during a trial. This affects you directly if you ever serve on a jury in a court of law in our state. At a trial, attorneys cannot introduce evidence of a defendant's insurance policy, even if liability insurance will pay a verdict against a defendant. Under Alabama law, attorneys cannot inform a jury that a doctor has previously committed malpractice. This is true even if the investigation finds that a healthcare provider did in fact commit malpractice and cause significant injury or death previously. And finally, often you must pay money back to your insurance company if you are successful in a case. For example, most health insurance policies contain a clause that allows the insurance company to demand the policy benefits back from you if you win or settle your case. Most, if not all, insurers will not offer to refund your premium payments for the coverage either. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis, Wright & Couch want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you, and thanks as always for watching The Attorneys right here on Alabama's 13.
Our final segment of The Attorneys, but still opportunity for you to get in touch with us. That information is on your screen, so feel free to chime in. We would love to hear from you. Gentlemen, our final segment here, something that we touched on as we were heading into break, and that is wrongful death. I see that made the list also.
Go ahead.
Yeah, in Alabama, we have a wrongful death statute, and it's different than most other states. It only allows for punitive damages. In most cases, you deal with compensatory damage, looking for your loss of income, medical bills that have been incurred as a result of the collision. But in Alabama, the wrongful death statute allows for punitive damages, not to compensate for the loss of life, because as a matter of public policy, you say, well, how do you do that? You really can't put a value on a person's life. But you look at the wrongful conduct of the defendant, how reckless they were and how wanton they were in determining what the value is in the wrongful death case. And then also, it really precludes a family member from talking about what type of support a loved one was maybe providing for a family. And so that's a very particular statute. I have friends who practice law across the country, and their statutes are very different when it comes to a wrongful death claim.
Yeah, you know, in other states, for example, you can talk about those missed moments that somebody's going to have because they were killed at the wrongful conduct of somebody else, like the ability to see a graduation or walk a daughter down the aisle. You're able to talk about those things, and the family is able to talk about those things. Able to talk about, as Courtney mentioned, lost income, as well as what really the family member meant to that family, that they were kind of the matriarch of the family, or they were kind of in charge of the family and really the glue that held the family together. You can't talk about any of those things in Alabama. It's just not allowed by statute. The legislature, in their wisdom, has indicated that they believe that all we can talk about in those cases is what it takes to deter the conduct of the defendant and punish the defendant for that conduct. So it's one of those things juries may not understand, but this is a good example to educate them.
I don't know if we can get through this in a couple of minutes or so, but contributory negligence versus comparative fault?
We could probably talk for a day on that. I'll start it and I'll toss it to Courtney. In short, Alabama is a state that follows contributory negligence, and what that means is if a plaintiff is even 1% responsible for the accident itself, they are barred from recovery. There are multiple exceptions to that, multiple exceptions, including if the conduct of the defendant is so egregious and wanton, then contrib does not apply. Other states are what's called comparative states. Courtney, I'll let you kind of explain quickly about that.
Well, and in fact, we're only one of 3 states that even still handle contributory negligence.
Okay.
But comparative negligence, you look at how much a plaintiff is at fault compared to the defendant's liability or fault. And then the jury then apportions the damages based upon the ratio of your damage, is how it works with comparative negligence. But oftentimes the jury is instructed that if you find 1% of fault on behalf of the plaintiff, that they're precluded from giving any type of recovery to them.
Okay.
I think jurors usually get it right on that issue, though. Even though we're a contrib state, they will consider and evaluate the full totality of the circumstances, and I think Courtney and I see that in the courtroom all the time. So even if you show 1% responsibility, but significant responsibility by the defendant, I think the jurors get it right in Alabama.
Time for a final thought, Courtney. Just a final thought from you.
Well, again, I want to thank Josh and his firm for this show. I mean, this is great public information. And hopefully we've given some information to folks who will serve on juries and just the public in general about the types of issues that we know, questions that they have that are going through their minds during the course of a trial.
And David, I'll tell you why we know it is because Courtney and I on a daily basis at our law firms are answering these questions to prospective clients. Where somebody walks in my office and talks about a medical malpractice case, and I have to educate them about what the laws are and how the law is really in some respects stacked against them. And they kind of scratch their head and say, we can't get into that. Well, this person did this in the past. Well, in another case we could. Those are just examples, of course, but these are questions we face on a daily basis with our clients. And we thought it'd be a good idea to do a show on it because, candidly, if we're facing these questions on a daily basis, I know the general public, the hardworking folks in this area have got to have these same questions when they get in that jury box.
And how about maybe we covered all 10, but maybe get these up on the Facebook page as well.
Absolutely. That's a good point.
Might be a good way to do that, and you can find the Facebook page for Hollis, Wright, and Couch. Just search Hollis, Wright, and Couch, and we'll get these up on that Facebook page as well. Gentlemen, thanks so much for the time.
Thank you.
Appreciate it, and we thank you so much for watching as well. Again, love to hear from you. Plenty of ways for you to reach us. Find them also on Facebook, search Hollis, Wright, and Couch, and on Twitter, that's Hollis_Wright. We appreciate you being with us, and we'll see you next week, folks.